Sequestration is what happens to an individual if you are bankrupt, and liquidation is what happens to a legal entity, so a company or a closed corporation. So if you as a person are unable to pay your debts, you as a person get sequestrated, while if a company is unable to pay its debts, the company or the closed corporation then gets liquidated. The process is managed in terms of the Insolvency Act, and then if it's a company or a closed corporation, the process is managed by the Companies Act.
Very much so. In your experience, how common is sequestration?
It's very uncommon. Our laws are archaic. We use a 1954 Act, which is due for law reform. So what we've seen with lockdown and with the slowing of business in the last year, there's been a substantial increase in businesses being compelled to go into liquidation. However, liquidation in Namibia and sequestration is very uncommon as a result of the drastic impact that has on a person's status.
Very much so, When you look at the different ways through which a company or closed corporation can be placed under liquidation, please talk to us about the various ways.
Okay, so you can either do it by the company itself, or you can be a creditor that goes to court to do it. So if a company sits there and the directors or the members of a closed corporation know that this company can no longer pay its debts, and if they continue to trade, it will be reckless, then they can either go to court themselves and bring an application to say, please put me in liquidation, or the directors and the shareholders can take a special resolution to say, we're unable to pay our debts, and the entity is placed in liquidation by BIPA. The other process that can be followed, if you are a creditor of somebody that doesn't pay you, you've got a judgment, the guy still hasn't paid, you can then approach the court by application to say, please place this entity or this person in liquidation, that the liquidator can be appointed to fairly distribute the assets to the creditors.
Very much so. My following question may go against, the capacity that you come in this morning as a liquidator and an attorney. Is liquidation always, the best resolve, final resolve, so to say?
It's sometimes the only option. So if you're in a situation where you are the creditor and the debtor doesn't pay you, and you've gone through the collection process, you've been unsuccessful, but you've seen that it appears as if assets are still there or assets have been hidden away, then it's normally your only option to try and recover those assets. While on the other end, if you're a person which is managing a company and this company is insolvent, and you see that I'm going to trade recklessly now. So recklessly, if you trade while not being able to pay your creditors, that's a criminal offense. So if you continue trading while being insolvent, that's a criminal offense. So then the right thing to do is to say, I'm throwing up my hands in the air. The law allows me to place this entity in liquidation, have a liquidator appointed, and clean it up, and I can start with a new business.
Once again, in your experience, how difficult a decision is that, claiming an insolvency?
There's a stigma on it. So in Namibia, there's a stigma on, firstly, this person is insolvent, and secondly, it's a very dramatic process. All your assets, if you are sequestrated as a person, all your assets get placed under the control of a trustee. The trustee is appointed by the master with a specific duty to protect the interest of the creditors. So what happens if a master appoints me, I need to collect the assets, and practically I sell them. So you sell everything. The person retains personal items and clothing and bedding, and there's a list of... But it's all your major assets are sold, and the proceeds then gets distributed to your creditors in terms of a ranking preference in the Insolvency Act.
And for the sake of our viewers who are wondering, how is a liquidator appointed?
So the liquidator is appointed in terms of the discretion of a master. So the master has a list of suitably qualified liquidators, and on application by the liquidator, the master then appoints somebody that is suitably qualified for the specific estate.
Fantastic. Should a person be liquidated, how does this impact his or her status?
So if you are liquidated, while sequestrated for a person, you are not able to act as a director of a company anymore. You probably not allowed to get debt anymore. While you have a trustee, you're not allowed to trade or conduct business. So you may have salary employment, but you're not allowed to trade. And there are certain positions which are excluded from a number of regulated positions specifically require that a person may not be unrehabilitated insolvent. And for practical reasons, if you cannot manage your own money, you shouldn't be managing somebody else's money.
Yeah. Very true. Mr. Cronje, any final remarks from you this morning?
Thank you for having me. And for our viewers, if you're in a situation where you're seeing that you're trading in a business which cannot pay its debts, it's worthwhile to consider liquidating that entity to prevent that yourself take the risk of being exposed to criminal procedures for trading recklessly.
Very much so. Thanks so much for being here this morning.
Thank you for your time.